Welcome to the NZIIA podcast. Here we talk all things international, from trade to geopolitics to diplomacy. The NZIIA seeks to encourage an understanding of the importance of global affairs to the political and economic well-being of New Zealand, as in this interconnected age, what happens beyond these shores affects us all at home.
Kia ora. It's Francesca here, producer of the NZIIA podcast. I'm just jumping on to give you a quick content warning. This episode contains content regarding genocide as well as the present and historical prosecution of individuals on the basis of gender identity and or sexual orientation. If this is something that may be triggering for you, please check out some of our previous episodes or the Instagram page or website for updates on what is to come next. If you do decide to listen, there will be a warning played before the most graphic accounts of these torturous prosecutions if you wish to skip past them. Thank you and enjoy the episode.
Hi guys, and welcome back to the NZIIA podcast, brought to you by the Youth Panel. It's me, Alex again, and today I'm joined by Jordan.
Hi Alex, thank you for having me. It's a pleasure to be here. It's the first time on the podcast, so I'm excited to talk about law.
Thank you very much for joining me today. So Jordan, do you want to introduce yourself and what you're interested in?
Yeah, hi everyone. My name is, as Alex said, Jordan, still that. My final year of Bachelor of Law and a Bachelor of Arts in International Relations and Politics at Victoria University of Wellington. My main area of focus in law is international law, specifically international public law and dispute resolution. And we have the immense honour of being joined by my friend, inspiration and former boss, Vinod Bal from the University of Waikato, who has just finished his dissertation in an area of international law on human rights. So Vinod, thank you for joining us.
Thank you for that introduction, Jordan. To call me an inspiration is probably a bit too much, but I'll take it. So as Jordan said, my name is Vinod Bal, but I go by Vinny, and I am a fifth and final year Bachelor of Law honours, conjoined with a Bachelor of Social Science, majoring in political science and sociology at Te Whare Wānanga or Waikato, the University of Waikato. And yeah, I guess my main areas of interest when it comes to law in particular are human rights, international criminal law, and international law as a general topic of how we mediate relations between states.
Cool. And we both have some international experience abroad, yours significantly more successful than mine. Last year, I went on exchange to Austria to study law, and I chose March of 2020 to make that international travel experience, which I don't know if you guys have been keeping up with the news in the past 2 years, but something happened recently that made that a very not ideal time for international travel. So I'm back, but you were significantly more successful. I believe you said you went to Berlin and Vietnam.
Yes, something like that. So my first, exposure to human rights and international law actually happened here in New Zealand, where I was undertaking research on the Rwandan genocide. And that was in my second year of university. Essentially, I was arguing that the genocide wasn't a result of ethnicity, but rather political actors putting people against each other. And ever since then, I was really fascinated by genocide in particular, but then it expanded into international law. So after my second year of law, I went over to Vietnam and I practiced in a bit of private international law, so investments and stuff like that. But then on the side, I managed to do a bit of anti-human trafficking work as well. So that was quite fascinating. Then the year after that, I managed to get over to Berlin. And in Berlin, I did a clinical human rights course co-taught by the Humboldt University of Berlin and the European Centre for Constitutional and Human Rights. So we focused on areas such as business and human rights, transnational crime, and gender. So again, really, really fascinating. And while I was in Europe, I took the flight over to London and managed to get a bit of work experience doing international trade unionism as well. So engaging themes of international labour law. And then currently back here in New Zealand, I co-founded a charity called Adhikar Aotearoa. So essentially we're a charity that aims to support, educate and advocate through policy and legal intervention the rights of queer and trans people of colour. So I've done a bit of work on new laws that are popping up. Obviously, conversion therapy is quite in the spotlight recently, so I've done a bit of work on that, the BDMR bill. And yeah, so quite an eclectic variety of stuff there.
Yeah, that's amazing. Honestly, all I can speak to is 2 months of law study followed by flight and then 2 weeks of isolation, eating a month's supply of chocobons. So yours is significantly more impressive. I remember you talking about the charity a while ago. How long has that been running for?
Yeah, so I think we incorporated it on January the 14th. So 7 months up and operating.
What are your future goals for the charity?
So that's a tough question, and probably one that I haven't grappled with too much recently. But to be honest, just to let everyone be their authentic self. There's a lot of stigma, discrimination, and just overall general not niceness towards the queer and trans population around the world, and for South Asians in particular in New Zealand. So I'd like to see a world, for my charity's sake, in New Zealand where everyone can be themselves.
Yeah. I think there's some commonality, even though we obviously study different areas of law, but they both fall under international public law. And human rights does seem to be not only underpinning both of our respective study interests, but also developing, and we'll get into that a bit later, but in terms of international climate law, human rights is becoming part of that. And obviously in gender and sexuality, it's a huge part. And then we can speak to some examples we were talking about before. So, for example, the US and Brazil and the Netherlands, there are some quite interesting developments in international human rights law, especially in the past few years.
Completely. No, that makes complete sense. I think a lot of what attracts people to the study of international law, as you rightfully say from my assessment, is human rights. The desire for us to be able to see each other as humans, and humans who actually deserve respect and dignity and who are afforded inalienable rights. So I'd agree with that contention that I guess with international law, human rights is the primal project, and the project that should possess most primacy as well.
Yeah, you mentioned before, you spoke about international law from a human rights perspective, and you brought up business, and that's quite interesting because usually business falls under private law. So maybe now would be a good time for anyone. I know Alex mentioned that he studied Laws 121, which is probably 99% of everything you need to know about law.
Exactly.
But for anyone who's not versed, fortunately, in the legal field, what would you say is the difference between public and private international law?
So international law, as you say, is juxtaposed into two areas, so the public and the private. Essentially, private international law deals with private actors acting beyond state boundaries. So it is when, say, for instance, a business in, let's say, the United States wants to invest money into Vietnam. There are a whole set of international obligations that states themselves have agreed to that businesses need to abide by. So essentially, the main difference is that private international law is all about private actors and how they can act in their relations between states and other businesses that may be located in other states. Whereas public international law, otherwise known as the law of nations, it's essentially the body of legal rules, norms, and standards that apply between sovereign states. So essentially, the actors there are public actors, they are states, and we call them public actors because they're accountable to the public. So that's the main difference there. And I guess substantively, obviously, with private international law, there's a lot to do with business and money interests, whereas with public international law, the substantive areas of focus are things like use of force, human rights, international climate change law, obviously a topic we'll talk about later. So that's the key distinctions there.
Yeah, and you mentioned that they are two separate bodies of law, which is obviously entirely correct. But would you say that they are beginning to blur a little bit recently?
When I was in Berlin, as I said, one of the areas that we took interest in was business and human rights. Now, businesses have typically never been considered to be subjects of public international law. The only subjects of public international law are states. However, we're now having discussions of things like the Business and Human Rights Treaty, which would then impugn businesses to act in certain ways to ensure that their business practices do not result in human rights violations. And obviously, we have a lot of examples of that. I believe the Swiss or German company NZIIA committed crimes against humanity in Africa. We had businesses such as Hugo Boss, which supported the Nazi regime during World War II. So we have significant interplay between businesses and public interests. But essentially, now we're getting to the point where we're starting to codify that, or at least that's something that I would like to see. I'd like to see that Business and Human Rights Treaty come to fruition.
Absolutely. I think that goes to a lot of what we're seeing now.
We're seeing that quite a lot in the inclusion of free trade agreements as well. There are a lot of clauses that involve making sure that you act in terms of the businesses and your foreign investment that are in the best interest of both populations and both governments. And so it seems like that idea of human security, which has also penetrated the international relations space as well, where humanity is the focus in both the security dimension, which has often been defined by a very cold ideology. It seems like that kind of human lens that you guys are talking about is permeating through the security and the economic trade lens as well.
Completely. I mean, a couple of years back, I believe it's 2013, but the United Nations introduced what they called the Guiding Principles on Business and Human Rights. And in, I believe it was Article 13 of those principles, there is an obligation upon states to ensure that the businesses that operate within the confines of that particular state remedy the potential human rights violations that their businesses may undertake. So you can see that there's a morphing of public international law to be purely focused on the state to more humanistic dimensions. And that's quite a positive change, I would suggest.
Because you also see it in the way that the IMF or the World Bank or the Asian Investment Bank, it's a lot easier to get investment loans if you can prove that your business helps the prosperity of lower middle class people, if it is sustainable, climate effective. You can see it in carbon credit trading. It's massive, billions and billions of dollars being committed by all these different international institutions to push business and investment in that more human positive direction.
Completely. I guess that relates back to the aims and purpose of international law. And Jordan, this is something that I'm sure you can comment on as well. But international law itself has always been optimistic and aspirational, and it has the rights of people in mind. So it's no surprise that we see this morphing. It just has taken a bit of time, obviously. The modern international law project is relatively new, probably 70 years old, and therefore we see this stuff coming to fruition now as opposed to the past, but seems to be in congruence with the purpose of international law.
Yeah, I completely agree with your observation that it's quite optimistic in nature. It's funny that you say that because I was studying the Paris Accord, and a prominent legal philosopher whose name I've completely forgotten mentioned that rather than a legally binding treaty, it's nothing more than an optimistic statement of good intentions. And of course, or at least that module was, is that true? Is the Paris Accord legally binding at all? The reason I mention the intersection between public and private law is that I believe in 2019 there was a case in The Hague that a private company which was polluting the atmosphere in the Netherlands actually violated the human rights of the Dutch people. And it was the first time in history that human rights, which is a field of public law, was used as legal reasoning in a private law case.
Completely. I think with that case in particular, we see the value and the use of strategic litigation coming through. Obviously, with that case, I believe it was in the Supreme Court of the Netherlands, we have that particular court holding that human rights were being infringed upon by the company producing emissions. Now, that, if we think about the metamorphosis of international law, from something that was predominantly state-focused into something that is now more business-orientated. Because when you look at it, I guess, you see that in the past, and I do recognise, and I don't say this with ignorance, but in the past, the main perpetrators of abuses of human rights were states.
Yeah.
But now we're coming to a time where actually, from my assessment, I'd probably say it's a 50-50 split. We have businesses doing terrible, terrible things. And conversely, we have states doing terrible, terrible things as well. So the metamorphosis is only natural, and it's quite an organic one as well. I guess on that particular point, or that particular case that you bring up, Jordan, I'm interested to hear your thoughts around the international laws that we have around climate change. Do you see that there is a cogent legal order there, or is it more just a bundled together set of laws that mean nothing?
Yeah, that's a great question. So that case, as well as being the first time that human rights have been used in a court case, was also the first successful climate change law case, and that was only in 2019. For some reference, there was a case in New Zealand in 2015 where a university student actually sued the Minister for Climate, arguing that our nationally determined contribution under the Paris Accord, which is basically New Zealand's agreement to take steps to mitigate the effects of climate change in order to reach the 1.5 degrees Celsius limit set out in the Paris Agreement, argued that basically, although we signed and ratified the treaty, our policies are not good enough to get that target. And that case was eventually thrown out because the minister at the time was outgoing. And so the judge basically just said, well, by the time that this case is going to go its full length, the minister will no longer be the minister, and it's a new government who has authority to make whatever policies they choose. So that was in 2015, and it's only in 2019 that we have the first successful climate change law case. So you're asking me about what I think about the climate change law regime. I am extremely cynical about this area. The Paris Accord, as I said, is often called a statement of good intentions. I do believe it is more than that. I think it is legally binding, perhaps not in a way that we think about treaties such as the Rome Statute, which covers genocide, as you were talking about before. But it does put legal onus on states to put forward policies that don't contradict what they've signed to. So the only issue with that is that nationally determined contributions, which is how we put the Paris Accord into practice, often at the complete discretion of the individual state, and come under quite a lot of other factors, economics or political climate. For example, when the United States under the Obama administration were ratifying the Paris Climate Accord, they were worried that their NDCs would not pass the Senate because the Senate was predominantly Republican at the time. And so they had to basically quite substantially reduce the aspirational nature of the policies they were agreeing to, and actually almost meant that the Paris Accord was not signed by the US. And if the US didn't sign it, a lot of other states would have pulled out as well. So the consequence of that is that we get a lot of emitting players in the international environment, bit of a pun there, agreeing to NDCs that are actually not good enough. Although they may feel that they are, legally bound to uphold those policies, they don't meet requirements of the Paris Accord, which is to keep global temperatures below 1.5 degrees Celsius, which is obviously not ideal because you've got a lot of these states who are meeting their commitments, often Pacific Island states, who feel the effects of climate change the most, who are actually contributing the least, and then vice versa. It's a very, very new area of law, and we are seeing a lot of promising examples of litigation. This case from the Netherlands has been cited quite a number of times in the past couple of years, so that is very promising. Hopefully we'll see human rights and international public law playing a much greater part in domestic legislation and litigation, which would be substantially more effective than relying on states to do the right thing after they've signed a treaty that says, here are our intentions.
Yeah, completely. I guess there's a couple of things that you talked about that I'd like to bring up. First is a plug for my university. The person that you noted took the case against the Minister for Climate. Her name was Sarah Thompson. She was a fellow law student at the university I study at. Now, conversely, you bring up the point around cynicism, and you're relatively cynical around international climate law. And I just want to tease this out a bit more. Does that cynicism extend to international law as a whole, or is it just limited to this particular area?
I think international law inherently requires a healthy amount of cynicism because politics does play quite a significant part. We see, especially in the United Nations Security Council, you see political and economic and international relations motives affecting the kind of laws and treaties that are being eventually agreed to. But in saying that, I don't think that makes international law as a field or a subject less worthy or weak, because they are having quite significant positive effects. Just this year, an indigenous group in Brazil has brought a claim to the International Criminal Court against the Brazilian president, Jair Bolsonaro, for crimes against humanity, genocide, and ecocide. And they're arguing, which goes back to climate change and human rights and the Rome Statute, actually, that by removing policies that were safeguarding the indigenous people of Brazil, as well as creating new policies that involve intervention into indigenous territories, indigenous lands, and social projects, it amounted to a systematic and intentional acts that had the effect of persecuting and destroying a culture and ethnic group. And that case is before the ICC right now. And so the reason I bring it up is that it's the first time that an Indigenous group is bringing a claim on its own to the International Criminal Court for crimes against humanity, genocide and ecocide, arguing by itself with the support of Indigenous lawyers, which I think is very cool. And if that case is heard successfully, that would be quite an important and positive example of international law having a great effect.
Completely. I guess that point around this particular case going before the International Criminal Court demonstrates the trajectory of international law. I guess in the past we have, for instance, the laws of coverture that subsumed women as property. Those laws are no longer around, and women have been entitled to take protection from international law specifically. We then have groups such as sort of what I'll talk about a bit later, but queer and trans persons who have then also become entitled to the protection that international law affords. And I think one of the areas of criticism that I would note is that international law historically hasn't done that well by our Indigenous communities globally.
Yeah.
We have UNDRIP, the United Nations Declaration of the Rights of Indigenous People. New Zealand was one of 4 countries that didn't sign up to it. So New Zealand, Australia, Canada, and the United States, I wonder why. But it's quite nice to see that the field of international, or the realm of international criminal law, is now being expanded to Indigenous persons, because it's about time. I guess sort of on a corollary point around the cynicism associated with international law, I would agree that international law does warrant a bit of cynicism with it. We see quite a lot of arguments against the system of international law just regarding its effectiveness. Back in 1994, UN peacekeepers stationed in Rwanda bearing witness while the most intensive ethnic slaughter in modern history was taking place. An estimated 800,000 to 1 million Tutsis and moderate Hutus who were killed in the most brutal ways, and the United Nations stood by and did nothing. Now that deserves reprimand and a lot of cynicism associated with it. But then in the same vein, I guess you've got to look at the positives. There was a time where chemical weapons were proliferated and used, maybe not commonly, but were used more than they are now on the battlefield. Now, with the Convention Against Chemical Weapons, we have 98% of the world's chemical weapons destroyed. The Antarctic Treaty System, again bounded in international law, has thus far enabled Antarctica to not be subject to large-scale degradation. And then we have small wins, actually, like the BRICTO arbitration, so BRICTO, BRCKO, which was an arbitration between Republika Srpska and Bosnia, which I'm sure you all will know back in the day were fighting with each other. So here we have these 2 states come together, subject themselves to international law through an arbitration, and instead of fighting each other, they settled their dispute, which is around the territory of BRICO, through peaceful means, so through international arbitration. I guess what I'm contending here is that, yeah, you're dead right. It deserves a lot of cynicism, but then I think there's a lot of hope for optimism, or a lot of calling for optimism through the ethos of international law in general.
Did you hear recently that, I believe it was only last month or the month before, France has released a statement accepting some accountability over the Rwandan genocide and asking for forgiveness, which is obviously quite a bit too late and is entirely a symbolic gesture now, but it is suggesting, as you say, some hope and some positive movement towards a more effective international law environment. Would you agree with that, or?
Yeah, I guess to some degree. The cynical side of me says, it's just because they got caught out and the public attention is on them. The French intervention in Rwanda during the genocide was termed Operation Turquoise. And essentially, what a lot of the academic commentators have been saying over the past years is that the French troop presence in Rwanda enabled free passage to the government of Rwanda that was then committing genocide against their own population. We even have had issues with France promulgating that they are not convinced that the government of Rwanda at the time so the Hutu extremist government, were the people solely responsible for genocide. Now, that's a contention that is abhorrent, because that government completely was responsible. I do get, however, that in response, the other side, so the RPF, the Rwandan Patriotic Front, that was led by Paul Kagame and eventually ended the genocide, also committed mass crimes against humanity and potentially genocide. There's a lot of comments on that as well. I guess what we have here is an international system with this particular example that was impotent, that was redundant. The world sat by and watched while these innocent people died, and we could have done something. And I guess we see the same situation playing out with Syria, and a bit of my research focused on the rights violations occurring in ISIS-occupied Syria, where we have had horrific crimes against humanity carried out. And again, the world is sitting by, as you say, because of political issues associated with Russia and the United States going back and forth. It's really quite sad that states and actually the people within them have to suffer because of political reasons.
I think that goes to the main reason for cynicism in international law, and I think Alex might agree extends to international relations and security studies, which is the role that power plays in international affairs and international law. So, for example, you mentioned Syria, and I know that recently a international human rights lawyer, an organization, I can't remember, basically argues that the United States' policies of drone strikes, which has been decades long, which the United States argues is a form of self-defense, is actually violating international human rights law and international law on the use of force. And the United States, in response, have said, well, it's self-defense in this continuing war on terror, which falls kind of under the argument that, well, there's no imminent attack, and there's no imminent attack, which is pretty conclusive in it itself. They've then consequently argued that they have their own domestic law and legislation that provides for these drone strikes in Syria. And domestic law supersedes international law, at least when we're considering the state. And the reason why other states and, the United Nations is kind of hesitant to do anything about it is because of the power that the United States has in international law and international relations. Would you agree that there's quite an emphasis on power when we're considering, how much progress we can make with international law?
There's a couple of things that should be touched upon there. You mentioned that the United States justifies their drone attacks by saying that they domestically enable it through legislation. Now, the issue with that is that we have instruments such as the Rome Statute, which obviously the United States isn't a party to, but even instruments like customary international law that prevent the killing of civilians. And we know from evidence that that has happened through drone strikes that the United States has been a part of. So to say that domestic law enables you to commit those crimes is incorrect, because indiscriminate killing, which obviously drone strikes can do, is what we call jus cogens. So I guess sort of a bit of an aside here, but jus cogens are predictory international norms. They're norms that no state can ever derogate from. And if a state does derogate from them, then it's the responsibility of the international community to hold it to account. So I provide an example, I guess. Say, for instance, today I decide to commit a war crime in New Zealand. Obviously, I would never do that. But say we have that situation that happens, and the New Zealand government doesn't hold me to account. Obviously, that war crime, depending on what it is, would be considered jus cogens, and therefore the inaction of the New Zealand government in itself would be illegal. But then secondly, it's the responsibility of all other states to come and hold me to account. So that's the first point there. It's that while the United States might use that domestic law justification, it doesn't stand up, because these are jus cogens norms, and no domestic law is allowed to derogate from jus cogens norms. But I guess secondly, and might be an unpopular contention, but while I see the desire to focus on American action in Syria, I would contend that Russia is an equally, if not worse, player here. I would assess that moral repugnance lies with the Syrian regime, and that's the regime that Russia is propping up. We've had numerous instances in the United Nations Security Council where both the Americans and the Russians have tried to put in proposals that have then vetoed by each other. And I guess what that, to me, speaks to is politics getting in the way of preserving human life. If you bring it back to the ethos of international law and accountability in particular, and that in itself is a truly disastrous situation because it's not what the law was envisioned for. It's not working. Obviously, that brings us to the question of reform, but I'm sure that's a discussion we'll have a bit later on. So I guess, again, a multifaceted answer there. I think that the Americans obviously have a lot to answer for, but then conversely, because of the things that we have been seeing in Syria being of use COVID's nature, the whole world has a lot to answer for. And I'm sure when we're old, sitting on our rocking chairs and we're reading books of history, this is probably going to be a moment that we're all going to hold our heads in shame, because we have situations in Ghouta, Syria, where 12, 13-year-old kids were subject to chemical weapons attacks, and you turn on the TV and you see them foaming at the mouth. The accident of geography is the only reason why we're not in a situation like that. So the onus truly is on the international community as a whole to come together and try and resolve issues like this, because when you leave it to the superpowers, then that's when political stalemate gets in the way.
Yeah, absolutely. And I think that is quite honestly the reason why I'm the most cynical in terms of the weaknesses of international law. Like, for example, speaking on intervention in Syria, when intervening into the territory or political independence of another state or using force against another state has to be in self-defense or authorized by the Security Council, and any use of force or intervention under self-defense must be reported to the Security Council and then subsequently voted on. But then we get these political stalemates happening and these vetoing, and a lot of states, such as the United States, Russia, are just simply ignoring that process, whether rightly or wrongly. It doesn't work. You get a stalemate and then nothing happens. And I think that's quite honestly the reason why I see the most need for reform in international law. If you want these processes to work, they need to be a bit less optimistic and a bit more practical, and remove that power component when we have these international disputes.
Yeah. One interesting remark I'd add to that is I used to be of the opinion that we should get rid of the veto altogether. But I don't think that's going to happen anytime soon. Obviously, those power don't ever give it up.
That was the New Zealand position from the start. We argued against the veto power.
Completely. And you can see the after effects of having that veto power there through situations that we have in Syria and stuff like that. But then conversely, I was having a chat in our international law class with Professor Alexander Gillespie, and he sat us all down and he said, well, actually, let's have a think about the use of the veto power. The veto power was not intended to stop all wars. What it was intended to do was to stop the next world war. And actually, so far, it's been successful. And as much as we hate that, it's true. Where I see the need for reform is when the P5 or the permanent 5 members of the United Nations Security Council will come together and actually agree on guidelines as to when or when not they will use the veto power. Because as we said, it's unlikely that they're going to give that power up. But it's a bit more likely that they could all come to the table and say, well, this is one situation where I wouldn't. Say, for instance, where there's instances of war crimes or genocide happening. But here is one instance where I would. And agree on those specified guidelines, because to be honest, that's probably what's most practicable in this situation.
I think we've stumbled across our first area of disagreement, that the veto power and the P5 have been the reason why we haven't seen a third world war. I think you give too much credit to the P5 and their substantial and regular use of vetoing, but maybe that's a discussion for another day, because we have to talk about your dissertation, which I found really interesting. Would you like to give some background on what you just written?
Yes. So my dissertation research is something that is obviously I hold quite dear to my heart. The issues associated with the persecution of queer and trans persons globally. Now, I'll ground my dissertation research in some context first. So I studied and researched an area of law that we call international criminal law. Now, international criminal law is essentially an international or subset of international law that criminalizes 4 particular crimes. So the crime of aggression, that's when one state invades another. Crimes against humanity, so there's quite a bit of them, from persecution all the way down to many, many others. We have war crimes, and then we have genocide. So those are the 4 crimes that international criminal law adjudicates upon and tries to provide accountability for. So the particular area of my research was in the area of persecution. And persecution is defined by the Rome Statute as the intentional deprivation of rights. So obviously needs to be a part of a systematic and widespread policy of an organisation or a state against a particular group of people. So it could be if I was the leader of an armed group and I went into a particular area of a country and decided to kill people. That would be the intentional deprivation of one's right to life. So persecution obviously could refer to situations like that, where we have the intentional deprivation of the right to life. But then it could also refer to the intentional deprivation of other important rights. So essentially, that's the context in which I did my research in. Crimes against humanity, or the specific crime against persecution against queer and trans persons, has been occurring for quite some time. We have situations in obviously Nazi Germany where 10 to 15,000 gay men were rounded up and put into concentration camps and killed. And even in those concentration camps, we have really, really horrific stories of how gay men in particular were treated.
Francesca again here. This is the warning I mentioned at the beginning of the episode. If you'd like to skip past these graphic accounts, please skip to exactly 40 minutes into the episode. Thanks.
I'd like to touch upon 2 stories. So one of the stories happened in Sachsenhausen concentration camp north of Berlin. I'm not too sure, my memory evades me. But essentially what we had there was prison guards collect gay men who were in these concentration camps, tie their feet together and immobilize them upright. And then they put water taps into their mouths and turn them on full. Obviously, the implication of this is that they drowned. And then what the guards did is they hung them upside down and slit their throats as to drain the water. Now, we have really, really horrific circumstances of torture like that happening in Nazi Germany. But conversely, we have situations that aren't relegated to history that happen on a day-to-day basis in the modern age. I guess one important point that I do need to touch upon is that the Nuremberg Tribunal, which was the international legal commission set up to deal with the crimes of the Nazis, never provided any form of justice to homosexuals. There was never any appreciation of the harm and the turmoil that gay men went through in the Nazi regime in particular. And what that did is it silently legitimized those crimes, and it subsumed those gay men to a subclass of human existence. And that's something that international law is the complete antithesis of. So we have that situation back in Nazi Germany, but then fast forward a couple decades and we have persecution of LGBT persons in ISIS-occupied Syria. We all know of the horrific acts committed there, and those horrific acts were extended to LGBT plus people. So there's reports of gay teenagers who were tied together with metal chains and then set on fire. We have reports of, again, gay men being thrown off buildings onto metal spikes, and then in the event that they were still alive, stoned to death by the ISIS militia. And more recently, 2017 onwards, up until the current day, we have persecution of gay men and lesbians in Chechnya, a semi-autonomous region of Russia. At least 150 gay men in particular have been subjected to extrajudicial killing and torture. And if they haven't been subjected to extrajudicial killing or torture by state forces, the state forces then hand those particular LGBT persons back to their families, and they give them a message: kill your child, otherwise we will do it for you. So we have various situations where a 17-year-old gay teenager was thrown off a 9-story building by his uncle to preserve the family's honour. As of current, we have no accountability for any of these horrific crimes, none at all. The people who commit these crimes are still walking free. And that, I'm sure all us here would agree, is a state of affairs that shouldn't be acceptable in this day and age. It shouldn't be acceptable anywhere. If someone commits horrific crimes, they deserve to face the strongest forms of accountability available. And essentially, that's what my dissertation looks at. It's how, through international criminal law, can we ensure that these people are put behind bars? Because essentially, and this is the unfortunate side of the Rome Statute, is that it provides no explicit protection for LGBT people when it comes to persecution. So my research looked at how we could expansively interpret the Rome Statute to ensure that we could get LGBT people covered. So I did that by looking at Article 7H, which defines persecution. And it says that persecution can occur against a variety of groups. The groups that I focused on were gender, and then secondly, groups as protected by international law. So what I looked at, or what I argued, is that when groups like ISIS or the Chechen government committed crimes against humanity against queer persons, or let's say gay men in particular, they didn't do it because of their sexuality. They did it because of their gender. Now, I know that this may not make a lot of sense, but trust me, it will. So what I argued or contended was that it was indeed the gay man's violation of a gender norm that rendered them susceptible to being identified. And if I give a practical example, so if I'm walking down a street, I've just gone clubbing and I'm wearing, high corduroy pants, something that people may stereotype to homosexuality. It's that particular act of me wearing something that is connotated to being feminine. That is what would render me subject to discrimination, not the fact that I am gay. It's the fact that I'm violating something that we call a gender role. Now, we have practical examples of obviously in ISIS. So ISIS occupied Syria. The group banned all men actually from shaving their beards, watching satellite TV, or wearing skinny jeans because, and I quote from their publications, only men who are feminine would do this. Now, it's no surprise that a lot of the men who were then persecuted in Syria because of their perceived sexuality, as exhibited through wearing skinny jeans, as exhibited through those other prohibitions that I noted, were then subject to persecution. When anyone in particular exhibits what are characterized as female behaviors, that they're automatically considered gay. And now that's obviously not the case. But the implication of that in situations such as being in Syria is that you can be subject to very, very severe forms of persecution. So again, it's actually the gender role violation as opposed to their sexuality. And these people are still walking around. They may not be in Syria now, but the people who perpetrated those crimes that I have mentioned, they still have their liberties. And that's an affront to justice. Now, obviously, this isn't an advantageous strategy to argue because it literally denigrates someone's entire identity. But then in the same vein, you need to start somewhere. And this is where I contend we start. The second argument that I made in my dissertation is that Article 7H, which again defines persecution, says that we can have groups that are recognised by international law that are afforded accountability mechanisms under the Rome Statute. So say we have those particular groups. Again, the particular groups there evade me, but gender was definitely included. Nationality would have been one. So we had a non-exhaustive list that was then expanded by the inclusion of other grounds that international law provides protection for. Now, essentially, what I was arguing here is that international law provides protection for queer and trans persons. And here there's a radical positivist assertion that because international law, or the traditional instruments of international law, haven't provided explicit protection to queer and trans people, that then they are not afforded that particular protection. So I had to come up against those arguments and try and contend that international law indeed does protect queer and trans person. So I turned to international refugee law, which obviously, if you're a refugee, you are fleeing a well-founded fear of persecution. So that is an area of law that is highly relevant to the area of research that I was doing. And essentially, we have the United Nations coming out and issuing guidelines saying that, yes, you can be fleeing because of your sexual orientation or your gender identity. So we have a big tick that this particular area of international law provides protection. Secondly, we have the International Covenant of Civil and Political Rights, which in Article 2.1 and Article 26 provide for the non-discriminatory application of rights. So back in 1991, we had a case before the Human Rights Committee, which is the United Nations committee set up to hear complaints. And we had a man whose last name was Toonen. Now, Toonen was an Australian national. He lived in Tasmania. And back in 1991, Tasmania still had laws that criminalised consensual sex between adult males. And he went to the United Nations and contended that that particular law was a violation of his right to privacy. So under Article 17 of the ICCPR, and it was a violation of the principle of non-discrimination as codified in 2.1 and 26. 2.1 and 26 of the ICCPR doesn't explicitly mention sexual orientation status, but what it does mention is the phrasing other status, and that, Mr. Toonen contended, could be used to expand the ambit of protection that international law provides. The United Nations agreed, and then the International Covenant of Civil and Political Rights was expanded to include queer and trans people, and as such, Tasmania repealed that particular law. So again, we have another tick from the United Nations and big instruments of international law. We have other main committees, so the Committee on Economic, Social and Cultural Rights, the Committee on the Elimination of All Forms of Discrimination Against Women, the Committee on the Rights of the Child, and the Committee on the Rights of Persons with Disabilities, all noting that it is impermissible to discriminate on the basis of sexual orientation and gender identity. Now, those committees are based upon the particular treaties, and those treaties are or have been ratified by 83 to 99% of all UN member states, and that evidences state behaviour in practice, which is, again, a really, really important source of international law. So again, we have state practice and evidence. We've got a tick there. And then conversely, we have civil society measures such as the Yogyakarta Principles, which is essentially a civil society measure where a group of academics got together in Indonesia and promulgated that international human rights law already provides protection to queer and trans persons. And they noted a couple of principles around what that international law framework looks like for queer and trans persons in particular. Civil society measure in general does nothing, but the fact that they have been cited by courts in Nepal and recently the Supreme Court of India, which is obviously the highest judicial organ of the world's biggest democracy. So again, that brings a lot of credence there. And then lastly, we have the Inter-American Court of Human Rights through their advisory opinion, OC 1803, noting that the principle of non-discrimination and equality forms jus cogens, so international laws and norms that cannot be broken. So again, we have civil society measures and judicial reasoning from international courts suggesting that queer and trans people are entitled to those rights. Now, there was one main challenge to this, and this is the threshold of something being universally recognised, or a particular group being universally recognised by international law as being deserving of the protection that it can give. And we have countries around the world that still have the death penalty for homosexuality on the books. So you can hardly contend that the protection of homosexuals would be something that is universally recognised, because it's definitely not. However, I argued that in the wake of the 2016 Orlando terrorist attacks, the main traditional challenges to LGBT rights actually changed tune for a bit. So we had states such as Lebanon. So we had Lebanon's Prime Minister Saad Hariri come out and say that those terrorist attacks against the 51 predominantly gay men in Orlando constituted a significant crime against humanity. We had Saudi Arabia coming out and saying that they pray for the recovery and the healing of all those injured in the attack, and condemned in the strongest terms the attack on innocent people in Orlando. We have the United Arab Emirates that promulgated that such criminal acts that target innocent civilians contradict all moral principles and human values. And then we have Russia and Egypt actually signing on to a United Nations resolution that condemned that particular terrorist attack. So what I argued was that these promulgations demonstrate that sexual and gender minorities are people with the right to life and the right not to be targeted due to their membership within a collectivity. They also recognise that acts of harm against sexual and gender minorities are at a minimum wrong, and this is all that is required for the universally recognised standard to be met. And essentially, that got rid of the biggest challenge that I had to this argument being accepted. Essentially, that is what my dissertation research was all about. Apologies for the verbosity there.
No, that was amazing. I know that in the Nicaragua case, Nicaragua and the United States, which is one of the most famous cases in international law, the court said that, our instruments work alongside customary international laws and do not supersede them. And in order for a customary international law to be created, you need statements of intent and state practice, which, as you mentioned, we're seeing some of. I do have one question for you, and that's that under Article 7 of the Rome Statute, Crimes Against Humanity, which we've discussed in a few different contexts now, Article 7H, persecution against any identifiable group on political, racial, national, ethnic, cultural, or gender grounds. In that case I mentioned before, the ICC now, the Indigenous people argued that by invading and destroying Indigenous territory, that amounts to ecocide with the intent of destroying the group. And they were arguing for interpretation in that sense. But the reason I bring it up is that in paragraph 3 of Article 7, it says that the term gender refers to the two sexes within the context of society and does not indicate any meaning different from above. And I've got two questions. The first is, what do you think about the inclusion of within the context of society? And secondly, obviously, when we're reading international law instruments, we read them within the context of the preamble or, statements of intent and the general context and purpose of the statute. And it's incredibly difficult to argue by anyone that a purpose of a statute, which was to prevent violence against anyone and promote equality and life and the pursuit of happiness for all groups, should not be extended or interpreted to include a group that is suffering from persecution and violence. So what is your answer to paragraph 3?
Jordan, there actually unfortunately are states that would disagree with the contention that you just made.
Oh, absolutely.
We had the delegation of Azerbaijan during the drafting committee stages of the Rome Statute say, and I don't quote verbatim, my mind's not that great, but something along the lines of, does the inclusion of gender within the Rome Statute prohibit the criminalisation of homosexuality in our national courts, in our national bodies? So there was a clear concern from the delegation of Azerbaijan, at least, that gender described by Article 7.3 would be used to prohibit the criminalisation of same-sex activities in particular countries. But essentially 7.3 is the result of a negotiating strategy that we call constructive ambiguity. And that's a term phrased by a legal scholar, Valerie Oysterweld. Essentially, during the drafting committee stages, we had two sides. We had women's groups who really wanted gender to be included, but then we had conservative states such as the Vatican and Saudi Arabia who wanted to ensure that gender wasn't included. Now, to reach a middle ground, they agreed upon 7.3. And essentially 7.3, as you said, says that gender is defined by the two sexes. So instead of gender being defined by sociological considerations, which is its normal understanding, we bring in biological concepts. But then we have that bit at the end within the context of society. And again, that was a concession to women's groups. And the implication of that is that the definition of gender within the Rome Statute is very unclear. But that's good for us because that means that the International Criminal Court judges are then left to decide if gender could be expanded to include sexual orientation. And I contend, as I just noted, that it does. So I guess that's sort of where the really, really odd phraseology of 7.3 comes from. It's essentially trying to keep really progressive groups happy and keeping really, really conservative groups happy as well.
That's really interesting. I hope for the sake of human rights groups and organizations and people around the world that we can have a more expansive or clarified interpretation, whether that involves expanding international law or just simply clarifying it to include what I think should universally be considered to include. I just noticed we've only got 3 minutes left, so it might be time to wrap up. I've actually got a bit of a positive story for you. You mentioned the concentration camps during World War II and the security guards not having accountability there. And it's very abhorrent that their violence against people on the grounds of sexuality and gender identity have not been fully clarified and targeted. But very, very recently, I think just a couple of weeks ago, we've got a 100-year-old former Nazi concentration camp guard standing trial for 3,518 counts of accessory to murder. And that is a very incredible extension of the criminal law, because we've got a trial for murder without any evidence of specific victims or specific acts. It's purely by him being there and him contributing to the camp that there's this trial. Unfortunately, the many, many life sentences that he will have, and people like him who have already gone through the courts, he's considered to be the last one. Life sentences for 100 years old people is probably only 12 days, but at least we've seen some accountability for the guards and what they did. But yeah.
Through my research and just through my general advocacy, I want to make sure that we don't get to the stage where we are providing accountability at a point where it is almost, as you mentioned, redundant.
Yeah.
Essentially, as you correctly mentioned, it is really, really good to see that they're finally facing their time in front of justice. But then in the same vein, we have the capacity to try and solve or provide accountability to these groups of people right here and now. All that we need is for the International Criminal Court to uptake a case based upon the legal reasoning I put in my dissertation research. And we will see a world where we don't have to wait for decades for accountability to fruit. We can get accountability straight away. And that's the type of international law that I want to see.
Yeah, I completely agree. Thank you very much for joining us today, Vinod. I learnt a lot and I was interested, which is very rare when we're considering law. So thank you very much.
Well, no, thank you for bringing me on. I really enjoyed it. Thank you so much.
No worries.
No worries, mate.
Have a good one.
Well, have a good afternoon, guys. See ya.
You too, mate.
See ya.
Bye. Hi, guys. Thank you very much for tuning in to another episode of the NZIIA podcast brought to you by the Youth Panel. You can listen to all our podcasts on Spotify at NZIIAYP. Follow us on Instagram as well, NZIIAYP, for all the latest information updates on what we're getting up to this year. Cool. Cheers, guys.